Now, Mr. President, if I may talk about something else. Last Friday, a three-judge federal appellate court made an important decision. It said that the President of the United States, President Obama, on January 4th of 2012, made some recess appointments when the Senate wasn't in recess. In other words, they were constitutionally invalid. The President made 4 appointments on January 4th, 2012, 3 to the National Labor Relations Board and 1 to the Consumer Finance Agency. He did it under his so-called recess appointment authority, which is defined in Article 2 of the Constitution. But the court said, no, Mr. President, the Senate wasn't in recess, that the only time you can make those appointments is between the annual sessions of Congress. And the Constitution also says those vacancies to which you appoint have to happen during that recess. Now, the chairman of the National Labor Relations Board made a remarkable response to the order of the court. The order of the court, by the way, vacated an important decision that the board made and said that 2 remaining NLRB members on the board are unconstitutionally there, so they vacated the order. Instead of recognizing the authority of the court, the NLRB chairman said, in effect, I'm going to hang up a sign that says, open for business. We have important work to do. And they're going to keep going. Despite the fact the NLRB has made 219 decisions with these 2 unconstitutionally appointed members since the first month of January 2012, all of which I would submit are invalid because 2 of the members who voted on the decisions were unconstitutionally appointed. So, Mr. President, I'm here today to call for Sharon Block and Richard Griffin, the 2 members of the National Labor Relations Board who were unconstitutionally appointed by the President, according to the federal courts of America, calling on them to resign their positions and calling on the President of the United States to nominate 2 more members for the National Labor Relations Board, and then let's do what the Constitution says we're supposed to do. The best known authority of this body, the United States Senate, is likely to be the advise and consent provisions of the Constitution. Article 2, Section 2, with the advice and consent of the Senate, the President shall appoint ambassadors and others. And there are about 1,100 of those that the President appoints. And 2 years ago, and then just last week, we streamlined the confirmation process a little bit to narrow the focus on the most important appointees and make it easier to get them confirmed. So those are the checks and balances that the Constitution meant to establish. They did that so that we would have liberty from a tyrannical executive branch, which is what the founders were worrying about. And the court has said that the President succeeded that. Therefore, these 2 members of the NLRB should resign immediately, pack their bags, and go home with our thanks for their hard work, despite the fact that the 219 cases they voted on ought to all be vacated and probably will be when someone brings a challenge to those cases. A new sign needs to go up at the National Labor Relations Board. Take down the sign that says open for business, put up a sign that says help wanted, nominations accepted. Now, Mr. President, the 3-judge Court of Appeals did an interesting thing. They actually read the Constitution in its plain English. Here's what the Constitution says. The President shall have the power to fill all vacancies that may happen during the recess of the Senate. Now, what is the recess of the Senate? Well, let's go back to the beginning of our country and for many years thereafter. Senator Sam Houston of Texas had to go from Texas to New Orleans and get on a boat and come up the Mississippi River and then ride a horse and take a stagecoach to get here. It took him weeks. Same to go home. James K. Polk from Tennessee, who was Speaker of the House, would take a stagecoach up to Pennsylvania and then follow the road, or go on the river up to Pennsylvania and follow the road to the House of Representatives. At one time, President Polk, after he became the president, had a vacancy in the Attorney General's office, and he wrote some person up in New Hampshire and ask him to take the job, that took 2 or 3 weeks to get the letter, and it took 2 or 3 weeks to get the answer, and the answer was no. So in those days, Mr. President, there were long extended periods in this country between the annual sessions of the Congress when the members of Congress were spread all over the country. And so the founders anticipated that, and they wisely put into the Constitution a provision that said during those times, the president may make a recess appointment while the Senate's in recess. And that person may hold the position until the end of the session. Well, over the years, that has changed. And various presidents have tried various ways to fill vacancies during a recess. And that has become something different in the last while. And this hasn't been just Democratic presidents who've done it. Presidents have become frustrated because sometimes senators don't give their advice and consent. I know about that. I was nominated by President Bush the first to be the education secretary, and the senator from Ohio at the time thought I needed a little examination and held me up for three months. Finally, the Senate agreed to my confirmation unanimously. That's what we're for. We're supposed to consider the president's nomination of Senator Kerry to be Secretary of State, as we are. We're supposed to consider the nomination of Senator Hagel as Secretary of Defense. And according to the law, we're supposed to consider the president's nominees for the very important National Labor Relations Board. But what the president did was make 4 appointments the day after we went into our annual session. He made those appointments. We went into session on January 3rd, 2012. He made these appointments on January 4th. The court said the Senate was clearly in session. Clearly in session, Mr. President. And so if you disagree with the Senate, if you're afraid you're about to nominate somebody who the Senate won't like, well then you better get somebody the Senate will approve, or else you're not going to get that nominee. The president said, no, I'm going to do it my way, so I'll just try to change this recess appointment and do it in a way that's more extreme than had ever been done before. I want to hasten to add that there's no excuse here that if the president hadn't acted in this way, the Senate might have held up the nomination for too long. Of course, the Senate has that right if it chose to. But in this case, the nomination only arrived 2 or 3 weeks before the president made his appointment. So we've got a straight out set of facts here, says the court. According to the Constitution, the appointment may only be made during the recess between annual sessions, and it was not. And second, it may only be made to a vacancy that occurred during the recess. And these 2 vacancies occurred months before the recess about which we are talking. Now, the chairman of the National Labor Relations Board says open for business. In fact, the board should not be open for business because the board only has 1 member who has been constitutionally appointed and confirmed, in his case, unanimously by the Senate. So the board, without a full quorum of 3 members, which it does not have, 2 are unconstitutionally appointed, the board can't issue regulations, can't decide cases, including appeals of decisions or unfair labor practices. Let me give you an example that might affect the state of Tennessee. We were very concerned last year, Tennesseans were, when a complaint began to make its way through the National Labor Relations Board affecting the Boeing Company and its decision to put a plant in South Carolina. In other words, Boeing, from a state that does not have a right to work law, wanted to put a new plant in a state that does have a right to work law. And the complaint was filed, which on the face of it made it look like that if you try to do that, it's just prima facie evidence that you're violating the federal labor laws. That's a very expensive delay for the Boeing Company, or it would be for any company. Well, that eventually got settled after a lot of expense. But let's say we have a small supplier in the state of Illinois who might want to move to, which is not a right-to-work state, might want to move to Tennessee or Virginia, which are. And someone files a complaint. Do we want a board there that's unconstitutionally placed who might rule that that's a prima facie violation of federal law? To have members of the NLRB who are not confirmed by the United States Senate raises the prospect that would undermine the right to work law in Tennessee and Virginia and all of the other states that have chosen to have one. So this has very practical, everyday application in the state of Tennessee. But even though the board can't issue regulations or decide cases, the rest of the NLRB can be open for business while the president makes nominations and the Senate considers those nominations in the regular order. For example, the NLRB could conduct elections. It could investigate allegations of unfair labor practices. It can issue a complaint. Administrative law judges can hold hearings. Regional directors can settle cases. The general counsel may seek to enforce orders. The general counsel could issue enforcement guidelines memoranda. They're all open for business, but the National Labor Relations Board is not open for business. Its open for business sign needs to come down, and a new one needs to go up that says help wanted, nominations accepted. Finally, Mr. President, there's a larger issue here. At the beginning of last year, I visited Mount Vernon. I mentioned it in the 2 minutes I had at the president's inaugural last week because it made such an impression on me. I was reminded that the American Revolution was about tyranny by a king. That was the danger. That was what caused people to sacrifice their lives. I saw in the National Archives this weekend the oath of allegiance signed by George Washington and his troops, which swore allegiance to a country that was not even formed yet. An allegiance that would have caused him to be executed if we'd lost the American Revolution. So there was a lot at stake when our country was founded, and so much of it was about liberty and about an ability to resist a king or an imperial leader. And George Washington himself so imposed his own character upon the American character by his modesty and restraint, by his decision to step down as general of the American Army. He could have been general for the rest of his life. By his decision to step down as President of the United States after 2 terms, he could have been president for the rest of his life. But at the beginning of our country, liberty to many people meant avoiding an executive that was too strong, that didn't have proper checks and balances. And our founders put into our Constitution checks and balances with the court and with the legislature. And of course, as we like to point out, Article 1 is about the Congress, about the legislature. And as I said earlier, perhaps the best known function that the United States Senate has is the ability to advise and consent. The president may nominate, but those important people, men and women, may not take their offices until they have been confirmed by the United States Senate. Well, this administration, I'm sorry to say, has not respected that checks and balances as I would hoped it would. I would suggest maybe a retreat to Mount Vernon for President Obama and the White House staff. The Obama administration has appointed more czars than the Romanovs. We've always had some czars, such as the drug czars, but they have 3 dozen. 3 dozen who aren't subject to the usual restrictions that we have through the appropriations process. And the most blatant example of the imperial presidency are the recess appointments at a time when the Senate, according to this court, was not in recess, in order to put onto those positions men and women with whom the Senate would not agree. If the president could do what the president did on January 4th, 2012 on a regular basis, we might take a recess break for lunch and come back and find we have a new Supreme Court justice. So, Mr. President, I'm here to suggest that the right thing to do would be to respect the tradition of checks and balances that are built into our Constitution. It's at work here because the president took an action. We didn't like it. And the third branch of government has made a decision that the president was wrong. the way to go forward is for the two members of the National Labor Relations Board who were appointed unconstitutionally to resign their position, for the president to nominate as rapidly as he can men or women to fill those vacancies. To the extent the committee on which I'm the ranking Republican, which oversees labor matters, has to do with that, I will pledge speedy consideration of those nominees. And let's get the National Labor Relations Board back in business. But it cannot be open for business today. It cannot be properly open for business today. Those two members should resign their position and recognize that the court has said that we still have in America a Constitution that provides checks and balances. Take down the sign that says open for business, put up the sign that says help wanted, nominations accepted. Mr. President, I'd like to include in the record and ask consent to do so my remarks on February 2, 2012 about recess appointments, which I made following the President's so-called recess appointments and following my visit to Mount Vernon.
Without objection, so ordered.
Thank you, Mr. President. I yield the floor, and I notice the absence of a quorum.